All right,
Your
look,
Honor,
folks.
Your Honor, I'm house because they failed to pay rent. I have 6 children. These people make $350,000 a year is what they claimed on the rental application. I'm going to lose health insurance tomorrow, and my house is going into a foreclosure period as of tomorrow is 90 days late. They have money. They had subletters or whoever living with them, and I don't know if they were running a homeless shelter, if they were pocketing the rent that their roommates paid. They've just been sitting in my house, sir.
This is incorrect.
Okay.
I'm Jordan. Jared Lepic,
Yes.
Unfortunately was diagnosed with influenza A this morning, so he had his Zoom going and can mic in if need be, but he's got very little of a voice at this point.
Okay. All right. And yes, I do see him signed in. All right. Andrew Elliott or Traversia, is it Burrell?
Traversia Borelli.
Okay. Sorry.
That's
all right. Okay. What are we doing on this case?
Last week, sir, you had asked that they be out of the house before the hearing today. And as of right now, they're still moving stuff out of the property. There are still people on property, including a couple of unauthorized additional roommates that weren't included in the lease. And we have yet to get in contact with Mr. Elliott. He is the named person on our lease. So we would just him since the 7th, and the last thing we received from him in writing was an email admitting to the debt owed and the wrongdoing on his part, stating that he can provide the court of a copy with this email. In his own words, he states, "We will obviously not refute what you are owed. We have no intention to. We would honor the court decision of the debt, which would additionally include legal fees. Given our contract is under the laws of Michigan, there is very little that can be garnished as the bulk of my earnings are earned as independent contractor." In this email, he proposed a payment plan that we were uncomfortable with agreeing to because he's offered us specific payment arrangements over the last.
Can I stop you, please?
Absolutely. It was $15,000 plus court costs of $234.43. If I may, could I give you like 90 seconds of backstory, sir?
Not really.
Okay.
Your Honor,
I don't know that I'm necessarily going to need it.
Okay.
Ma'am, are you moving out?
Yes, we've returned the key. I have a couple of friends currently helping me move out the remaining things. I'm actually at the U-Haul Center right now, and they are getting the rest of the items out presently under the supervision of the land manager.
Okay. So what they're claiming is owed?
I am.
You are?
Yes, I am. We owe.
How much do you think you owe?
So we owe December and January. That's $10,000. We paid a $1,000 late fee in November and a $2,000 late fee in September and October. We believe that these should be subtracted from the total owed due to illegality of those fees. Also, we were subjected.
How much is monthly rent?
Your Honor, monthly rent is $5,000 a month. This is a 4,000 square foot house that we were under contract for them to purchase. And we have done a series of short-term leases as they were waiting on the city.
Okay. So here's the thing. Is she right about, she just listed off, I think, $4,000 of late fees that they paid?
No, sir, that is incorrect. Those were from the previous lease. See, at first we did a 60-day lease, and then we extended that once their house was not sold. So we have 2 prior leases to this short-term lease, and we only enforce late fees on one of documentation of all this, sir.
So can I.
Right.
I do have claims that ACHs were sent that were never received to my account, sir, as well as proof of funds that I received in December and no payment was made out of that. The last communication I had about a payment arrangement was on December 13th, and I was informed by Mr. Elliott that day that his wife had sent an ACH. However,
okay, look, folks. Oh, ma'am, here's what's going to happen. What date are you going to be out of the premises?
We're already out.
Your stuff is still
out.
Right.
And they have surrendered the keys?
Yes, and it's in the process of being removed as we speak. So we are out. It'll be another hour or 2, I think, before it's all of our stuff is gone.
So then the only issue is what's owed.
Right. I also want to bring up, if I may, Your Honor, we were subjected to a wrongful lockout, so $4 for a locksmith as outlined in Michigan's anti-lockout statute, totaling $450, which I also have evidence of.
Okay. All right,
Your Honor,
folks.
Your Honor,
Yeah.
I'm house because they failed to pay rent. I have 6 children. These people make $350,000 a year is what they claimed on the rental application. I'm going to lose health insurance tomorrow, and my house is going into a foreclosure period as of tomorrow is 90 days late. They have money. They had subletters or whoever living with them, and I don't know if they were running a homeless shelter, if they were pocketing the rent that their roommates paid. They've
No.
just been sitting in my house, sir.
This is incorrect.
Okay. All right. So here's the thing. Possession has been granted. There are 2 parts to the case. Possession's been granted or surrendered to the plaintiff. So possession is not.
Sorry.
Pardon?
There are still people at the house. One of them is house, and unfortunately, our property manager expired at noon today, as it is the last day of the month. So any clean out of anything left behind, I'm going to have to go assess for any damages left on my own next week.
All right. Okay. So here's what I'm going to do. They've surrendered possession of the unit. Ma'am, to your knowledge, are there people in the premises?
Yes, there
Ms.
is.
Burrell? Are there people still in the premises?
I don't know. I would have to text them. I don't know if they're on the premises presently, but we were told that we could get the remainder of the items out. So they would be doing that if they are not presently at the U-Haul Center where I am now. I'm just
So
using
here's
my
what I'm
phone
going
to
to
do
do.
this.
Possession to the premises has been surrendered. Ma'am, as of, given everything that I'm hearing, your management contract expires, what, at midnight tonight? Is that the deal?
Property manager anymore.
Hang on. I hear you. I'm just trying to, because you're in North Carolina, right?
Yes, sir. But I will have to make
Okay.
a trip up to North Carolina to assess anything.
I know. I guess you're out of state. You've got a property manager here that won't be the property manager tomorrow.
Yes, sir.
So what? I should let you guys talk and then I'll just go back and then come back out. Because either you're going to listen to me or not. Possession's been surrendered. I'm going to give the authority, I'm going to grant to the plaintiff the authority to prevent waste under 4.201I, that you may lock and secure the premises effective 3. And that is so that you can get your property manager, go over there. You can order a locksmith. You can change the locks at 3 p.m. today. Whatever else needs to get out, if you don't get it out by that time, you said you surrendered, you're giving them the keys. They giving you grace to get some of the stuff out. If it's not out, not out.
That's
But the
perfectly fine, Your
premises
Honor.
will be locked.
Thank you.
Then the issue regarding the money is going to have to be done. Now, I might as well, because the parties don't seem to agree, set this matter for trial. You have to come up next week. Is that correct, ma'am?
Yes, sir.
Okay, so trying to time this, if you come up, how long are you going to be up here?
Very short amount of time, sir, as I have children in North Carolina in school. So a day.
Okay. So if I I was just going to set this for a trial. So in person, because apparently there's going to be a lot of documentation. So I'm trying to set it. So here's what I'll do. Because we're really talking about the money, but we got to get the premises secured first. So we've dealt with that. What's my date? March the 4th? 11th. All right. So what I'm going to do is I'm going to set a non-jury trial as to the money issues for March 11th, 2025 at 9 a.m. That's in person. So I've tried to set that, ma'am, I tried to set it out far enough so that you could make arrangements or do what needs to be done to come up. We'll hear it that day. So if it has to be a one-day trip, it's a one-day trip. But I've just tried to put it out to, I think allow you to secure the premises. You're going to come up here, check on it. That way you can assess what damages or other things there may be there. Bring ledgers, all other documentation you want the court to look at on March 11th, and then we'll hear your case. Okay?
Ron, I'm ready to ask one question.
Sure.
Rather than pushing it out, I can make arrangements. I will make it work. Like I said, we're actually going into a 90-day foreclosure period tomorrow. And so time is kind of of essence.
I could do is the 18th. What day? Yeah. The best I could then do is February 18th. I could push it up to that date. Will that be better for you?
Yes, sir. Thank you so much.
So non-jury trial in this matter then will be set for February 18th, 2025, 9 a.m. Okay.
And one more question. Will Mr. Lepek have to appear as well, or will me be appearing sufficient just because he can't afford time off of work right now?
Well, he might want to have himself, if you're here, he may want to have himself. I will allow understanding childcare, work, those things. I would allow him to appear via Zoom.
Thank you. And as far as Mr. Elliott?
So that he's present.
And Mr. Elliott?
He needs to appear. If he doesn't appear, then I do what I got to do.
Okay. Thank you, sir.
Your Honor,
Thank you.
may I ask a question?
Sure.
My partner might not be able to get off work either, but I can show up. Is that a problem?
I will give you the same. Okay. I will give you the same opportunities that I give the other side in fairness. So you may appear, but he would have to be available via Zoom. And are Elliott and Burrell.
Your Honor.
Elliott's.
Why aren't they here?
I'm here, Your Honor.
Ms. Burrell was dismissed. She's not a party and she's not a lawyer.
Your Honor, if I may.
Go ahead.
I have evidence. I didn't know whether I was still allowed to appear in person as a result of the notice to have me dismissed. My partner is not able to get off work, but I have evidence for the court in defense of my partner.
Ma'am, I see now the notice of dismissal. You've been dismissed from the case. He's not here. He needs to be here.
Understood. I've been messaging with my partner to see if they can do something to make it. On the meantime, I do have evidence that I have been given that I can put.
Needs to be here.
Okay.
If not, I'm going to default him because he needs to be here.
Understood.
When is he going to get here?
I don't know. Again, my partner is in the middle of work, doing everything that can be done to be present.
Well, it's to be fair to each side. I give him 20 minutes. He's got to be here. If not, I'm defaulting him. Will that work for you, Mr. Lloyd?
20 minutes it is, Your Honor.
All right.
It'll be 10:15 our time.
Okay, that works.
Yes, here.
That's Mr. Lepek, right?
Yes.
Your Honor, I'm appearing on behalf of.
Andrew Elliott? No response. Would you like to take a default? I gave you.
Your Honor.
All right, raise your right hand. Do you solemnly swear affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Go ahead, your claims.
Your Honor, there's doing already right now the amount of 15,000. There is 584. There is a question, Your Honor, about late payment charges, and if you want to address those, the court had commented on in the last hearing, and because of the amount.
Yes, and they were rather large.
Might I make a pitch?
Certainly.
Your Honor, what's going on in this case, I agree, as a purely landlord-tenant case, the amount of the late payment penalties is large. The sale of the real property based out of earnest money and late performance of a purchase agreement, the amount is perfectly normal. I mean, I'm told that this was a $700,000 home being sold normally 1% or 2% of earnest money. And so in terms of a good faith attempt for the parties to establish a number that could reflect the consequences of the default, I think, but not unconscionable. I don't know what the standard of the code like.
I think it is, well, I would say that the late fees are unconscionable, and also the late fees can't be liquidated damages. In the scenario you put up, they could be in a certain respect. In this instance, the late fees have to be related to the landlord's ability to collect rent in some reasonable amount. So I would not allow them. If you want a hearing on that, you show it to me, then.
I see it a different way. In the context, I think I am less shocked because I see 2% would be a typical earnest money deposit. This is less than that. But in the context of monthly rent payments, I'm not going to make that argument. Your Honor, there is now, we have an not earnest money, a security deposit that I want to be applied. I've got damages of, we'd like to apply the security deposit of $8,550, and what we'd like is a judgment in the amount of $7,034. I don't have my costs.
7,000.
034.60. Now that's the net judgment.
After application of the
After application, I have a judgment for the.
So here's what I would do. Make it clear under the further orders provision that the court is permitting this security deposit to be deducted since they vacated the premises, so that the full judgment is actually the full amount, and then the security deposit being deducted, so that we don't have, because I think there's going to be a problem if we do it the other way.
I have prepared a form, if you can. I'll prepare it, I'll offer to the court and I've got it right.
All right. And your court cost in this case, I have 130. I don't.
Process, so we go and we got 75.
I have the process serving. I have a 0 service fee on both. I have no service fee. Okay.
So that would give us 205, I believe.
Yes, 205. All right. Thank you.